there, and welcome to Employment Law Show. We are back, and so are you. It's good to have you along. John Scholes here with me, Lior Samfiru, employment lawyer, of course, Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. You want more information beyond this show, you can reach out. First, I'll give you a great website called pocketemploymentlawyer.ca. It's free, it's anonymous, and rolled into that is the Severance calculator, which we will refer to several times over the next half hour. I guarantee that has been used by over 2 million people in this country. Over 2 million people have used the Severance calculator. It's free. It's there anytime for you to use at pocketemploymentlawyer.ca. And to reach Lior and the team anytime, 1-855-821-5900, help@employmentlawyer.ca. That's the email. Lots to get through in the show today. 5 things employees should know about medical leaves. That's in just a bit. But we always start off, pal, with the case of the day, the week that was, a matter you've been dealing with.
Yeah, John, I'm glad to be here and talk employment law. You know, you may be watching us at home right now on the weekend and you're thinking about going back to work after the weekend. Maybe you're a bit apprehensive because you didn't have a good week. You're worried about what to say to your employer. Maybe you're dealing with an ultimatum. You have to respond to your employer. Well, this is a good time right now. We'll cover things that you need to know. Chances are we'll touch on the issues that you've dealt with in the workplace, and we'll give you some path towards a resolution. Of course, if you're in a situation where you're not going back to work, maybe you lost your job, you learn a lot on this show about your legal rights and about what to do if you lost your job, how to understand what you're owed. It's so important. We have all these rights in Canada when it comes to employment law, when it comes to our workplace. The problem is that most individuals, and you know this, John, don't understand or appreciate just what those rights are. Well, on this show, we educate you, we inform you, we tell you what you need to know, and we arm you with that information. And of course, if you always want to take that next step, you want to have a private chat with me or an email exchange, we'll give you that contact information so you can take that step. But a week that was, situation that came across my desk over the past few days. So I spoke with a lady who called me after she lost her job. She had worked for her employer for about 2 months or so, just over 2 months. She was let go. She wasn't really given a reason. And when she called me, really what she was frustrated about is the fact that the company had not yet returned her personal property from the office where she worked. She had contacted them. She had some personal items. They didn't get back to her, so she was frustrated, understandably. And she called me and she wanted to know how to deal with that. So I told her what to do. I told her to give them a bit of time, follow up with them, tell them when you want to come in, and if they don't help you, let me know and I'll get involved. But as I was talking to her, I found out a bit more about her situation. So she had worked there for 2 months. She was let go. They said it wasn't the best of fit, and they didn't pay her any severance. She didn't expect any severance because she only worked there for 2 months. But here's the thing, and I hope that our regular viewers know where I'm going to go with this. The fact that she only worked there for 2 months does not mean she doesn't get severance. John, she was not on probation. And the reason she wasn't on probation is she never signed an employment agreement that put her on probation. Probation is not automatic. So even after 2 months of employment, John, she was owed severance. In fact, she was owed up to 3 months' pay. Now, that's more than the length of time that she worked. So I'm going to help her get that. She was absolutely dumbfounded to find out that she's owed that severance. But there's important reminders here. Number one, you're not on probation automatically. Probation is only created if you sign an employment agreement that specifically puts you on probation. Otherwise, you're not on probation, even if you started a new job. And beyond that, short service employees are treated disproportionately better than longer service employees. So you may have only worked for a company for a few months. You could be owed a few months severance. You'd be surprised by how much you're owed. So if you lose your job, whether you work for a month or 50 years, you have to give me a call. You may be well surprised by what you're owed. She was. I'm going to help her get what she's owed.
Why is it disproportionately better for short service employees? Why the number?
Well, the reason, the purpose behind severance is to help someone find another job while they're unemployed. And just because you work somewhere for a short period of time doesn't mean you're going to find a job immediately. In fact, it may be harder for someone that worked for a short period of time to find another job because they're going to have to explain to a prospective employer why they only worked for a few months with their previous company. And because of that, short service employees get even more severance or disproportionately greater severance than longer service employees.
And I guess that disproportionate amount will increase with a tougher job if you've got an exclusive sort of career, or if you're older for that matter, I guess, right?
Yeah, the harder it is for you to find another job, maybe because it's your age, maybe you have a medical condition, maybe you're in an industry when there's just not a lot of jobs. all those factors can significantly increase the amount of severance that you're owed. So it's not a simple analysis of if I worked this long, I get this much severance. We have to assess every situation. That's why never, ever sign that severance letter without going through that analysis.
And as I mentioned off the top, anytime pocketemploymentlawyer.ca, the severance calculator is rolled into that. You can make it a home game and find out how much severance you would possibly be owed. You may not be getting let go at any time, but just to give you a ballpark number of what you should be looking at. After that, you can carry on and talk to Lior, 1-855-821-5900. But employmentlawyer.ca, go to that website. Across the top, you'll see the Knowledge Center, drop-down menu, media. That's where you're going to find all our past radio shows and TV shows as well, like this one. And the radio show's good. It's an hour long. We do it across the country, have for almost a decade. We're getting a little old, pal. Almost 10 years we've been doing that. But we get a ton of calls on the shows every week, and we cherry pick a few of them. We play them back here, and we dissect them a little bit. So I want to do our first call for the day now, Lior.
This isn't for me. This is for a friend of mine. She was told a couple of weeks ago that the guys that she works in a sales position, are retiring. And they gave them 10 weeks notice where they're still working. So she's worked there for 11 years. She makes about anywhere from $50,000 to $60,000 and no talk of severance.
Oh, there's going to be talk of severance.
Well, I'm going to talk about severance right now.
That's right.
So let's first mention the fact that they gave her or are giving her 10 weeks notice of termination. And that's important because those 10 weeks notice do count towards her severance. So if you get advance notice of the termination of your employment, that period of time counts towards your severance. But the fact that it counts doesn't mean you're not owed much more than that. So let's talk about this specific lady who we know worked there for about 11 years. She's being let go with 10 weeks notice. So the question is 10 weeks enough? Rather than me tell you how much she's actually owed, rather than just spoil the fun, let's go to our severance calculator. You can find that at pocketemploymentlawyer.ca. And let's see what the actual amount is, how much she's really owed. So we know that this lady, you see that on the screen, she's been there for 11 years. She's making right around $60,000. She was let go with 10 weeks notice, while you see on the screen that what she's really owed is anywhere from 9 to 12 months of severance. 9 to 12 months. Now, that's less the 11 weeks that she's received, or the 10 weeks she's received. That's still a lot of severance. And I see this very often, John. Someone receiving advance notice of termination, just not receiving enough. So chances are, if you're let go, you're still owed much more than the notice you've received. And the way to deal with that is simply to go to pocketemploymentlawyer.ca and understand how much severance you're owed. Of course, it's free, it's anonymous, so check it out.
Is the advance notice kind of a rare thing? I'm thinking that if I'm an employer and I need to let somebody go, I don't want them just lurking around for 6 months, 3 months, 2 months, because they know the job's coming to an end. Maybe their performance will go down. Maybe they'll be bad-mouthing me. I don't know.
You're right, and it's exactly for those reasons that most employers don't really give advance notice. They terminate and they pay severance. Now, I would say in about 20-25% of cases, we see advance notice. But even in those situations, chances are you're owed more notice than what you've been given, and the employer has to make up the difference by way of severance.
In between this, the radio show, the TV shows, Lior, I don't know when he has time to practice law, but he does a lot of live streaming as well on Facebook and YouTube at ST Lawyers. At ST Lawyers, you want to follow along and contribute. Get a lot of questions. We want to talk about a couple of them here. In fact, question number one for today's show, Lior, is this. What option does an hourly employee have if their manager keeps cutting down their usual hours? Is that just part of the job?
Well, the question is it really part of the job? Now, if you took a job as an hourly employee, and your hours always have changed. Sometimes you get a bunch of hours, sometimes you don't get a lot of hours, and it changes from week to week. Then that's the term of your employment, and there's not much you can do about that. But if your schedule has been consistent, you usually worked a certain amount of hours, and now your employer is starting to change that. Now they're saying, well, we're not going to give you the hours that you're used to. Now we're going to give you less hours. Well, wait a second. The employer then is changing the terms of employment. And any time we think or we see a change of terms of employment, we have to think constructive dismissal. So yes, if you're an hourly employee, you are used to a certain number of hours, now those hours are reduced, you may be able to treat that as a termination, as a constructive dismissal. You don't have to accept it. So a good place to start, as always, if that's what's happening to you, give me a call. Let's talk about it and understand exactly what you're owed.
If it's not a major decrease in hours, I guess you could say, but it's enough where it's going to disrupt your income a little bit, but you really like working there. You like the boss. You like everybody about the workplace. Can you say, can we try this out temporarily for a little bit and see how it works, but I'm not going to sign off on this completely?
Yeah, a good strategy in that situation would be in writing, always in writing.
Right.
Send an email, a text message saying, employer, you've been changing my hours. I'm going to try it out and see how things go for the next 3 weeks, and then we'll discuss this. So put that in writing, because you don't want to be considered to have accepted this change permanently. If you're considered to have accepted the change forever, you can't go back on it. So if you're going to try it out, as John said, if you take it for a little while, but you're not sure if you want to accept it forever, say that in an email. By doing that, you're going to preserve your rights.
And if this person is let go by this employer, maybe they don't like that idea, their severance is going to be based on the previous job where they had all full hours. Correct?
Exactly,
Okay.
yes. If your hours are reduced and you say, no, that's constructive dismissal, then that severance is calculated on the hours the way they were before they were reduced. Very important.
Short break. We're going to take it now. When we come back, 5 things employees should know about medical leaves. That is on the way, but I'll give you a couple numbers and some emails as we head out for a short break. 1-855-821-5900. Get hold of Lior and his very capable team, and help at employmentlawyer.ca. Employment Law Show continues, coming right back. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Employment Law Show. John Scholes with Lior Samfiru, of course, employment lawyer, Samfiru Tumarkin LLP. Reach out anytime, 1-855-821-5900, and employmentlawyer.ca would be the website. Want to get into this, pal? This is 5 things employees should know about medical leaves. Number 1, these are all important, by the way, so make sure you listen closely. Is there a limit to the amount of time an employee can take for medical leave?
I get that asked all the time. I need to be off. Is there a limit? Can I get in trouble if I'm off work for too long? And the answer is no. There is no limit as to how long you can be off work. And it all comes down to what your doctor says. You can be off work for medical reasons for as long as your doctor says you need to be off. Maybe that's a week, a month, maybe it's a year, maybe it's longer than that. Hopefully it's not. But if it is, that's okay if your doctor supports you and you have that doctor's note. And what your employer cannot do is impose a time limit. You can only be off for a month, then we're not going to keep your job. It doesn't work that way. You can be off and not have to worry about losing your job for as long as you need to. Now, what's important is to have that doctor's note. So if your doctor's note initially said you're going to need to be off for a month, but you need to be off longer after a month, you're not ready to come back to work, you need a new doctor's note to tell your employer that's been extended. Now we're looking at more time. So keep your employer updated with that doctor's note. And if your employer does anything to you, that would be illegal. That could be a human rights violation. That could be a wrongful dismissal. You name it. With that doctor's note, you're protected, and there isn't any time limit.
Is there confusion sometimes? People say, yeah, but Lior, I only have 10 sick days. How can I be off for 2 months?
So 10 sick days means your employers decided they're going to pay you for 10 days a year if you're sick. And that's fine. But what this doesn't mean, it doesn't say anything about how long you actually can be off work. Now, the rest of the days may be unpaid, but you could be off for a month, for the whole year, if that's what you need for medical reasons. There may be other benefits that you'd be entitled to. There could be short-term disability and long-term disability benefits through your employer's insurance policy. You may qualify for government benefits like EI sickness benefits. So the number of sick days that you have has absolutely nothing to do with the period of time you're allowed to be off from work.
Next point is this: does an employer have the right to ask an employee for detailed medical information?
Another thing that I see happen all the time, employers say, well, you told us you can't work, but we need to know more. We want to know what medical condition you have. We want to know what medication you're taking, what doctors you're seeing, and we want to assess if we agree with that. Nonsense. Absolutely not. Your employer cannot demand to know what your medical condition is. That is personal and private information. What they're allowed to know, and we call this prognosis, they're allowed to know, can you work and can you not? How long are you going to be off work? Is there any accommodation that you need? Those are legitimate and important questions to ask. What they cannot demand is to know what your medical condition is, whether you're suffering from a bad back or a broken leg or from depression. Ultimately, it does not matter. What matters is whether or not you can work. So you're able to say, no, employer, I gave you a doctor's note saying I cannot work. That's all I'm going to give you. If you want more information about the length of my absence, I can give you that. But I'm not going to tell you what the condition is, what medication I'm taking. That is offside. And an employer is not allowed to punish you for refusing that information. And it's always a bad idea to open that door by giving your employer medical information that they're not entitled to have.
We're talking about 5 key points employees need to know about medical leaves. Number 3 is this: are employees obligated to let their employees keep them informed as they go on through this medical leave, date when they'll be back, so on and so forth?
It is an extremely good idea that you don't forget about your employer when you're off on a medical leave. So as a rule of thumb, I want to say that if you're going to be off for a while, once a month, contact your employer. Okay, even if there's not anything major to tell them, remind them that you're there. Send them an email or a text message saying, just so you know, employer, I'm still working on getting better. I'm still hoping to be back to work at some point, and I'll be in touch. That's it. It's that 1 or 2 lines. That's all you need. And what that does is it prevents your employer from saying, oh, I hadn't heard from you in so many months. I thought you resigned. It allows you to maintain your rights. It allows you to maintain your job and the right to your job. So very good idea to stay in touch with your employer.
Point number 4, it'd be good to have your partner Sivan here with the Disability Law Show that we run here as well. But does an employee have to return to work if their disability benefits are cut off or denied while they're on that medical leave?
So you're off work, you're sick, your doctor says you can't work. You've applied for disability, and maybe you've received disability benefits. And at some point, your disability insurance says, that's it, we're going to cut you off. We expect you to go back to work. But all along, you know you can't work. Your doctor agrees with you that you still can't work. Well, what happens then? Well, what happens is we have to separate the insurance issue and the work issue. With respect to work, all that matters is whether you have a doctor's note that says you cannot work. Your employer can't make you come back to work against your doctor's advice, even if the insurance company has cut you off. If your doctor says you are not able to work and you have that note and you provide your employer with that note, that's all that matters. And an employer that tries to punish you or threaten you or say you've resigned because you didn't come back to work contrary to your doctor's orders is doing something illegal. Again, human rights violation, wrongful dismissal, you name it. Now, with respect to the insurance issue, the insurance is actually similar. If your doctor says you should not be working, you cannot work, the insurance company should not be cutting you off. And if they are cutting you off before they should, we need to deal with that. You know, as you know, John, at my firm, we have a team that deals with these issues exclusively. That's how often it happens, unfortunately, people getting cut off their disability coverage. So if that happens to you, the good news is it's not difficult to resolve. We can either get you reinstated back on benefits or get you compensation. So ultimately, your doctor is what matters, even in dealing with the insurance company.
One more point on this. We're talking about things employees need to know when they're off on the disability leave, medical leave. Can an employee be replaced while on leave or even terminated when they return?
So the way this works is your employer has to essentially keep you on as an employee, and when you're ready to come back to work, try to bring you back. Now, that assessment happens at the time you're ready to come back to work. In the meantime, while you're off, yeah, your employer is allowed to run its business, and if that means bringing in someone to do the job that you used to do, they can do that. They can't fire you while you're on disability. When you're ready to come back to work, you tell your employer, good news, employer, I've been cleared, I'm able to come back to work. At that point, your employer has to make all efforts to bring you back if it's possible. They have to find your old position if it's available. If it's not available, find a similar position. If there's legitimately no position, they've tried, they've looked, there's just nothing there for you to do, at that point and only at that point can they let you go with your full severance. Too often, though, I've seen employers not try to bring someone back, not making that effort or preferring to just kind of forget about them. That's illegal. If your employer is not trying to bring you back, if they're not cooperating with your return to work from a disability leave, that is illegal. That's a problem. We can deal with that. If that happens to you, get on the phone and give me a call.
And the accommodation threshold in that regard is pretty high as well, right? They have to do quite a bit to make sure you can come back, and comfortable for that matter.
So sometimes you can come back to work, but you're not able to necessarily work the way you used to. You need some help, some accommodation. Maybe you need modified duties, modified hours. Maybe you need some support in your job. If you need that and your employer knows that from your doctor, that employer has to make it happen. They have to find a way to accommodate you. And too often I see employers not wanting to, it's too much of a pain, we don't want to, only come back when you're able to do your job the way you used to. That's illegal. That's a human rights violation. That duty to accommodate is one of the more important obligations that employers have. So don't just accept your employer's refusal to accommodate. Let's talk about that if that's your situation.
I mentioned employmentlawyer.ca, that website. You can go there anytime to find a radio show across the country that you can tune into on a weekly basis. Phone call number 2 from our radio shows is coming up right now.
I was working at another company. I was approached by someone that I used to work for to come to work for him, so I left that position and went to work for him. Due to unforeseen circumstances, my daughter's been placed in my care, and she's too young to be at home by herself. They want me to start work at late in the evening at 5 o'clock at night now. If I say I can't do it and they fire me, where do I stand with that?
So right before this call, we talked about the duty to accommodate. And oftentimes the duty to accommodate happens in the context of a disability. But another common situation is in the context of family obligations. So we call this accommodation based on family status. And what that means is your employer has to provide accommodation for you and support in situations where you need help to provide care for your children. So maybe what that is a situation where your child needs some medication. You need to be home to give that. Or there's no one to care for them and you need some flexibility with your start hours or your finishing hours so that you can be there at home. That accommodation has to happen. And if your employer refuses to accommodate, and too often I've seen employers say, that's your problem, employee, you figure that out. Well, no. The law makes it the employer's problem as well. So in this particular situation, if that employer won't accommodate childcare obligations, and there's really no way to provide childcare without the employer's support, that employer has to make it happen. Oftentimes, a letter from me, it's all that's needed to get that fixed. I've done this many times, it works like a charm. But yes, your employer has to accommodate those family obligations that you have.
Again, that was a phone call from one of our radio shows. We'll get to another one, but first we've got to take a short break, right? So we'll get to that. In the meantime, the number to reach Lior and crew, 1-855-821-5900. The email you can go to is help@employmentlawyer.ca. It's the Employment Law Show. More coming up. People think you have to sign back a severance offer by a deadline. Employmentlawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at employmentlawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. Employmentlawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at employmentlawyer.ca. All right, welcome back, Employment Law Show. A few minutes to go. Thank you for tuning in again this week. I want to reach out to Lior and his awesome team, best in the country, 1-855-821-5900 and help@employmentlawyer.ca. Plus the website built just for you, free, anonymous, with the severance calculator rolled into it, pocketemploymentlawyer.ca. But Lior, I want to get to our third phone call for this show right now.
I worked for this company, and I was using a piece of machinery, and it broke down. And so I worked for them for 22 years, and they wanted me to pay for it. So then they fired me. Do I calculate what they owe me?
And you were there 20 years, I think you said. Is that right?
22 years.
Machine operator?
High-end electronic machine that I was using.
And how old are you?
I'm 48.
You break it, you fix it.
Well, not
you break it,
so
you buy
fast.
it.
You break it, you buy it, maybe. Maybe you can offer to buy the machine.
Yeah, exactly.
So this actually happens very often if you think about it, that you're working on a machine, some piece of equipment, and it breaks. Maybe you even make a mistake, okay? And as a result of that, it breaks. Does that mean that you're on the hook for it? And the answer, no. If it's not something you did deliberately, if it's a natural and normal accident in the course of business, you don't have the legal obligation to pay for it. Now, if you did something you weren't supposed to do with the machine, and you knew the machine is not meant for this particular purpose, and you did it anyway, and we told you and you knew it, yeah, then that's a problem. You may have to pay for it, and you could even be disciplined for not following procedure. But in most cases, if it's an honest mistake, something happened, then you can't be really penalized for it, and you certainly can't be fired for cause in that situation. So as long as this is an honest mistake, there's no world where this would be a termination for cause. And I want us all to remember how difficult it is to terminate for cause. Let's say he made a mistake. Let's say he actually did something he wasn't supposed to. Let's assume that. That's still not cause in most cases. It would have to be pretty bad, pretty extreme for that as a one incident to be cause. He would have almost had to deliberately damage this machine for that to be cause. So because it's not cause, he's let go. He is owed his full severance. So the next question, we know that. How much severance does he get? For that, we're going to go back again and use our severance calculator. We're going to go very quickly to pocketemploymentlawyer.ca. We're going to use that calculator, plug this information in, and actually see what this person is owed. So he's been there for 22 years. He's 48 years old. He operates a machine. He hasn't been given any severance because his employer says, oh, we have cause because you made a mistake with the machine. Not cause. It's a wrongful dismissal instead. And we see in the bottom there that what he's owed is right around 18 months of severance. 18 months. John, I did some calculation. It's a salary of $60,000. That's right around $90,000 extra that he is owed. That's why it's so important to give me a call if you lose your job. Even faster than that, to go to pocketemploymentlawyer.ca to understand what your entitlements are. It's free, it's anonymous, there's no names you have to put in there, you don't have to put in your phone number, it's there for your information. So always the first place you go to if you lose your job, whether it's because you did something wrong or it's a restructuring, you always go to pocketemploymentlawyer.ca.
We have time for one more question. This is going to come from terminationquestions.com. Again, free, and you can contribute to the show as well through that. In a verbal agreement, my boss stated I would be promoted. Months went by, nothing changed, and after communicating with my concerns, I was told my chronic health problems prevented the promotion from going through. Is this considered discriminatory?
So if you're not promoted because of your age or your medical condition, that's illegal. You don't need to be a legal expert to understand that you cannot be not promoted, you cannot be penalized, you cannot be treated differently because you have a medical condition. That's easy to say. That's a human rights violation. The problem here, I suspect, is different than that. I always say document everything. And the reason I say that is I expect some people may not tell the truth. If someone screwed up, you can expect that they won't tell the truth. So how do we deal with that is we document things. So what would I have told this person to do? First of all, if you're promised a promotion, document that. Send an email to the boss saying, boss, confirming today you told me that I can expect a promotion in January of next year. You've just documented that. If your employer then says to you, we're not going to give you a promotion because of your medical condition, go back to your office immediately, send an email or a text message to your employer, confirming today you told me that because of my medical condition, you're not going to give me this promotion you promised. By documenting that, now you have legal recourse. You can pursue a human rights case. You can pursue a wrongful dismissal case, a constructive dismissal case. So always, always, always a good idea to document everything that you can. If you wish something was in writing, you put it in writing yourself. You don't need the company to say anything. It doesn't matter if the company agrees. You just do that, and you protect your rights by doing that.
Because you always say the chances are they're not going to admit to it or something to this degree.
Do you really think that employer is going to admit, yes, we committed a human rights violation?
Yeah.
Probably not. Chances are. That's why you don't give them that opportunity. You do what you need to document things so that when you need it, that information is right there.
Again, that question came from terminationquestions.com, which you can use anytime, and that'll be it for another show. Join us next time, and feel free to email and join on one of our radio shows as well. You may get on the air, right? 1-855-821-5900, the number to reach Lior and his team. help@employmentlawyer.ca, and then, of course, pocketemploymentlawyer.ca. Free and anonymous with the severance pay calculator as well, so check that out. We'll catch you next time on the Employment Law Show.